Trump loses on tariffs again. Welcome to Law and Society. Please subscribe. I'm going to go over the Federal Circuit opinion about the tariff situation. So I'll do a short, brief explanation of what happened. So the federal court, the circuit court, which is the appellate court for the federal circuit that oversees administrative and regulatory courts, ruled en banc, meaning the whole court, which is 11 judges, on a 7-4 majority-minority opinion that the Court of International Trade's ruling that Donald Trump's tariffs were not properly authorized under the International Emergency Economic Powers Act was a proper ruling. So the act, IEPA, that Donald Trump used to impose his tariffs, the appellate court agrees with the district court, does not give presidents the power to impose tariffs on other countries. So the tariffs, the legal basis of the tariffs are wrong. And the appellate court, like the district court, gives examples of many instances where other laws lay out specifically the power of the president to tariff some country or a tariff in a situation. And those laws very specifically delineate what the role of the president is in imposing such tariffs. And they are limited by scope and time and by other limitations that are provided in the text. So their text of the law that Congress gives to the president delegates to the president the power to tariff. Because the power to tax and tariff and the power of the purse is Congress's power, is an Article 1 branch of power. Congress has to delegate that power to the president. And it has over time. But it has done so specifically, and it has used the words tariffs, duties, excises, or other similar synonyms of those words like tariffs and duties to explicitly give the president the power. IEPA does not, that statute, the International Emergency Economic Powers Act, does not give the president the power to impose any sort of tariff or tax. It gives the president power to regulate. So, with that said, that's where it stands right now. The appellate court for the Federal Circuit of the Federal Circuit in the United States has ruled that Donald Trump's tariffs are invalid. But the court has stayed its own order until October to give time for the Supreme Court to hear the case. So it is, the tariffs, I suppose, remain in effect because there's no explicit ruling that the tariffs have to stop right now. And at the very end, the court says that in light of the jurisdictional ruling that the Supreme Court had in Trump v. Casa about the applicability of this law on a jurisdiction, it remands the case back to the Court of International Trade to determine whether it has jurisdiction under the new understanding of what a law, what a ruling, a district court ruling, how wide its impact can be. And I mean, if I'm thinking about it off the top of my head, if it's this International Court of Trade that has exclusive jurisdiction over tariffs and who seeks anything to do with trade and tariffs, it has exclusive jurisdiction, then when it rules on tariffs, that should apply to all tariff related questions that are being brought in the case, which means the Court of International Trade has the exclusive jurisdiction to impose the tariffs, and that order itself is enough to stop Donald Trump. And I hope that the Supreme Court, of course, the Supreme Court is not going to do that. It's going to hear the case. But I hope that the Supreme Court will agree in terms of jurisdictionally that the district court had the jurisdiction to stop and that the tariffs should stop immediately. But but the appellate court doesn't do that. The appellate court says that go back and look at it and see how wide your jurisdiction is to enjoin these tariffs. So the applicability of the tariffs is essentially enjoined, and we're going to have to wait for the rest of the ruling as it goes up on appeal. So that's the short part. If you don't want to go into the details of it, you can probably say goodbye now. Thank you for being here. Please like and subscribe. Please share. I rely on your sharing, your liking, your subscribing, and it has a huge impact on how YouTube shows my videos to others who may like similar content. With that said, I'm going to read you excerpts from the ruling and comment as I go along. This case involves the extent of the president's authority under IEEPA to regulate importation in response to a national emergency declared by the president. Since taking office, President Donald J. Trump has declared several national emergencies. The president has departed from the established tariff schedules and imposed varying tariffs of unlimited duration on imports of nearly all goods from nearly every country with which the United States conducts trade. In response to the declared national emergency, the president imposed what this opinion refers to as trafficking tariffs. Based on the executive orders, the president stated that the circumstances constituted an unusual and extraordinary threat which had its source in substantial part outside the United States to the national security and foreign policy and economy of the United States. In imposing these tariffs, he called to be acting under the authority of IEEPA and specifically found that action under other authority to impose tariffs was inadequate to address this unusual and extraordinary threat. So they chose the wrong statute, but they continue to say that, he has the power under this act, which now two courts and an appellate court has said that he does not. On April 2nd, 2025, the president imposed what this opinion refers to as reciprocal tariffs. Reciprocal tariffs took effect on August 7th, 2025. In May, a 3-judge panel of the Court of International Trade held that both the reciprocal tariffs and the trafficking tariffs exceeded the president's authority under IEEPA and permanently enjoining the government from imposing these tariffs. We also sua sponte decided to assign the case to the court in banc. So the Federal Circuit on its own decided, sua sponte means on its own, without either of the parties asking for it, has decided that the whole court is going to rule on this issue because it is that important. The Constitution grants Congress the power to lay and collect taxes, duties, imposts, and excises, and to regulate commerce with foreign nations. Tariffs are a tax, and the framers of the Constitution expressly contemplated the exclusive grant of taxing power to the legislative branch. When Patrick Henry expressed concern that the president may easily become king, James Madison replied that this would not occur because the purse is in the hands of the representatives of the people. So the historical context here is very important. And our framers understood that the power flowed from Congress, from the people, to the president, something that this president is trying to take away from Congress. And Congress, with the MAGA majority, has in many instances laid down and not taken a stand. And the Supreme Court has in many instances steamrolled district courts and went along with this regime, which really gives me pause to think of how somebody would rule in this case when, our Congress has given the Court of International Trade exclusive jurisdiction over tariffs and anything to do with tariffs and excises. So, then going back to the briefing, the ruling again. At the time of the founding, and now this is the historical story of the tariffs and how the story changed from tariffs. At the time of the founding, and for most of early history of the United States, tariffs were the primary source of revenue for the federal government. Setting tariff policy was thus considered a core congressional function. In 1913, the 16th Amendment was ratified, granting Congress the power to lay and collect taxes on incomes from whatever source derived. This ability of Congress to impose a domestic income tax reduced the importance of tariffs as a source of revenue for the federal government. And so for the last 115 years, the government and the economy of the United States has been held up by income taxes by citizens and people who are authorized to work, and even people who are not authorized to work. People who work in the United States pay the taxes, and that's where the coffers are filled from. Very direct from the people. And it is ironic that this is the time that this president is trying to take away from the people the right to decide tariffs, because taking away Congress's power to decide is taking away the representative government's power, because Congress is the biggest and the closest body of government to the people, which is held accountable every 2 years in the House of Representatives. In the late 19th and early 20th centuries, Congress began to delegate to the executive limited authority to activate or suspend tariff rates through international agreements. That presidential authority to increase rates was cabined in various respects, including limitations on the president's authority to increase rates by more than a certain percentage of established statutory rate. the United States International Trade Commission was established, and one of its responsibilities was to provide recommendations to the president in making adjustments to the tariff schedule. So there are all these different laws, and the predecessor to IEEPA, Trading with the Enemies Act, empowered the president to investigate, regulate, or prohibit any transactions in foreign exchange during wartime. In 1933, Congress expanded the Trade with Enemies Act by authorizing the president to deploy the power to investigate, regulate, and prohibit foreign transactions during other national emergencies besides war. So expanded the president's authority under this act. But then IEEPA came around. IEEPA is the result of this legislative effort and is consistent with Congress's stated goal to revise and delimit the president's authority to regulate international economic transaction during wars or other emergencies. So in a way, IEEPA was to revise and delimit the authority to regulate. So it was given to broaden the authority, but also to specify what the authority was, which was to regulate and not to tariff. It's a very important distinction here. IEEPA provides that after declaring a national emergency pursuant to the NEA, which is another statute, the president may investigate, block during the pendency of an investigation, regulate, direct, and compel, nullify, void, prevent, or prohibit any importation or exportation of any property in which any foreign country or a national thereof has any interest. Notably, IEEPA does not use the words tariffs or duties, nor any similar terms like customs, taxes, or imposts. IEEPA also does not have a residual clause granting the president powers beyond those which are explicitly listed. So, a lot of statutes will have a clause that gives the president some sort of a gray zone. IEEPA doesn't have that gray zone. It's very clear, and it does not use any language of tariffs or duties or customs or imposts or taxes. Congress passed numerous other statutes that authorize the president and executive branch to impose or modify tariffs on imports in certain circumstances. Notably, every congressional delegation to the president of core legislative power to impose tariffs includes well-defined procedural and substantive limitations. Provisions of the Trade Act similarly authorize the executive branch to impose tariffs on imports, but only once certain conditions set forth by the statutes have been met. The president may specifically direct the trade representative to respond to unfair trade practices that violate trade agreements or burden or restrict United States commerce, including by imposing duties or other import restrictions on foreign countries responsible for the harmful conduct. As interpreted by the government, IEEPA, unlike these other statutes, would impose no such limitation on the president's authority. And that's probably why Donald Trump picked this statute, because it has no limit to the authority. Congress doesn't limit to the authority, but his, motley crew of lawyers didn't take into consideration the fact that IEEPA doesn't authorize tariffs to begin with. And this is important, this court says, talking about the harmonized tariff schedule, while executive orders are not ordinarily law within the meaning of the Constitution, the challenged executive orders, if authorized, would modify the harmonized trading a tariff schedule of the United States. These modifications are thus purported laws of the United States, and the lawsuit challenging tariff effectuated by such modification arises out of a law of the United States providing for tariffs. And therefore, this executive order has the impact of becoming a law because it changes the tariff schedule. The only issue we resolve on appeal is whether the trafficking tariffs and reciprocal tariffs imposed by the challenged executive orders are authorized by IEEPA. We conclude they are not. First, look at the statutory text. IEEPA authorizes the president to take certain actions in response to a declared national emergency arising from an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. IEEPA authorizes the president to investigate, block during the pendency, and I read that part. The statute bestows significant authority on the president to undertake a number of actions in response to a declared national emergency. But none of these actions explicitly include the power to impose tariffs, duties, or the like, or the power to tax. The government locates that authority within the term regulate and importation, but it is far from plain that regulate importation in its context includes the power to impose the tariffs at issue in this case. Notably, when drafting IEEPA, Congress did not use the term tariff or any of its synonyms like duty or tax. And in enacting IEEPA, Congress explicitly set out to cabin the president's authority, providing for authorities which were both more limited in scope and those of the Trade with Enemies Act and subject to various procedural limitations. In each statute delegating tariff power to the president, Congress has provided specific substantive limitations and procedural guidelines to be followed in imposing any such tariffs. It seems unlikely that Congress intended in enacting IEEPA to depart from its past practice and grant the president unlimited authority to impose tariffs. The statute neither mentions tariffs nor has procedural safeguards that contain clear limits on the president's power to impose tariffs. Contrary to the government's assertion, the mere authorization to regulate does not in and of itself imply the authority to impose tariffs. The power to regulate has long been understood to be distinct from the power to tax. In fact, Congress vests these authorities in Congress separately. In fact, the Constitution vests these authorities in Congress separately, meaning in the Constitution's section, Article 1, Section 8, Clause 1, and Clause 3. It is that all duties, imposts, and excises shall be uniform. In a separate clause of the enumeration, the power to regulate commerce is given as being entirely distinct from the power to levy taxes and imposts, and as being a new power not before conferred. The Constitution then considers these powers as substantive and distinct from each other. While Congress may use its taxing power in a manner that has a regulatory effect, the power to tax is not always incident to the power to regulate. Indeed, there are important examples where Congress has granted the power to regulate to the executive branch without delegating the power to impose tariffs. government has not pointed to any statute or judicial decision that has construed the power to regulate as including the authority to impose tariffs without the statute also including a specific provision in the statute authorizing tariffs. Regulate must be read in the context of these other verbs, none of which involve monetary actions or suggest the power to tax or impose tariffs. So going back to the grant of power in the IEEPA statute that I read earlier. The government's interpretation of IEEPA as providing the president power to impose unlimited tariffs also runs afoul of the major questions doctrine. The government stating that there is no limit to the cap of the tariff in IEEPA itself. The Supreme Court has explained that the doctrine, the major questions doctrine, the Supreme Court has explained that the major questions doctrine applies in cases in which the history and the breadth of the authority asserted by the government entails vast economic and political significance. In such case, there may be a reason to hesitate before concluding that Congress meant to confer such authority. When the major questions doctrine is implicated, the government must point to clear congressional authorization for an asserted power. The tariffs at issue in this case implicate the concerns animating the major questions doctrine as they are both unheralded and transformative. The Supreme Court has explained that where the government has never previously claimed powers of this magnitude, the major questions doctrine may be implicated. Since IEEPA was promulgated almost 50 years ago, past presidents have invoked IEEPA frequently, but not once before has a president asserted his authority under IEEPA to impose tariffs on imports or adjust the rates thereof. Rather, presidents have typically invoked IEEPA to restrict financial transactions with specific countries or entities that the president has determined pose an acute threat to the country's interests. Other instances where IEEPA has been invoked, presidents did so to freeze assets, block financial transfers, place embargoes, or impose targeted sanctions on hostile regimes and individuals. Even under IEEPA's predecessor, which is the Trade with Enemies Act, a president has invoked his authority to impose tariffs on only one occasion, and on that occasion the tariffs were of limited scope and duration. The invocation of IEEPA to impose tariffs on nearly every country in the world is undoubtedly a significant departure from these previous invocations. This lack of historical precedent, coupled with the breadth of authority that the government now claims, may be a telling indication that the government's reading of the statute is incorrect. Additionally, as already discussed, tariffs are a core congressional power. The basic and consequential trade-offs that are inherent in the president's decision to impose the trafficking and reciprocal tariffs are ones that Congress would likely have intended for itself. The executive's use of tariffs qualifies as a decision of vast economic and political significance, so the government must point to a clear congressional authorization for its interpretation. Because it's about trillions of dollars. It's about a lot of money. We discern no clear congressional authorization by IEEPA for tariffs of the magnitude of the reciprocal tariffs and trafficking tariffs. While the president, of course, has independent constitutional authority in these spheres, the power of the purse, including the power to tax, belongs to Congress. Absent a valid delegation by Congress, the president has no authority to impose taxes. Given these considerations, we conclude Congress, in enacting IEEPA, did not give the president wide-ranging authority to impose tariffs of the nature the trafficking and reciprocal tariffs simply by the use of the term regulate and importation. In the government's view, we should discern that Congress intended to include in IEEPA the power to impose tariffs because it enacted IEEPA with knowledge of a judicial precedent which recognized the delegation of tariff authority to the president under the Trading with Enemies Act, which is IEEPA's predecessor, and contained the identical regulate importation language. This court says, the court noted that the executive does not here seek, nor would it receive judicial approval of a wholesale delegation of legislative power. A temporary measure, the Trading with Enemies Act was a temporary measure calculated to help meet a particular national emergency that is limited in scope and amount. Both trafficking tariffs and reciprocal tariffs in this case are unbounded in scope, amount, and duration. These tariffs apply to nearly all articles imported to the United States, impose high rates which are ever-changing and exceed those set out in the harmonized tariff schedule, and are not limited in duration. The tariffing and reciprocal tariffs assert an expansive authority that is beyond the express limitations of the precedent holding, and thus beyond the authority delegated to the president by IEEPA. So, with that said, the court then talks about the issue of the enjoinment and says we remanded back, as it is with the ruling on the tariffs. The court affirms that the Court of International Trade's holding that the tariffing and reciprocal tariffs imposed by the executive orders exceed the authority delegated to the president by the IEEPA text. We also affirm that the Court of International Trade's grant of declaratory relief that the orders are invalid and contrary to law. So, the court vacates the grant of permanent injunction and sends it back to evaluate it on the basis of what the court calls the eBay factors and the Supreme Court's precedent in Trump v. Casa. With that said, that's the summary of the 45-page majority decision. I have included in the description box the whole opinion, and you can read the concurring opinion and you can read the dissent. I did not read that because this case is going to the Supreme Court, because the Supreme Court is likely going to hear it before October. And what really irks me is that even this court, the appellate court, leaves it hanging in the balance of whether the tariffs are to be imposed or not, and which means Donald Trump is going to, abuse his power to keep imposing these tariffs. And he already talked about it on Truth Social and, attacked the court for their ruling. And then he says, how their Supreme Court is going to imply that the Supreme Court is going to side with him. And so we're going to see what a very friendly Supreme Court to Donald Trump, not even to the rule of law or even the Constitution, does in this case, because it's about the word regulate and about the word tariff, and it's pretty statutorily clear, and this court makes it clear, and the reasoning provided by this court adds to the reasoning provided by the Court of International Trade, which has exclusive jurisdiction over tariffs and trade issues. So with that said, thank you so much for listening to the long version. Please like and subscribe and share. Your input, your comments, your sharing, your subscriptions really help me out and tells YouTube that this is something that others would want to watch, and then shows my material to other people. So please do like, share, and subscribe. And with that said, thank you so much, and I will talk to you soon.